Good morning, everyone. Thank you for joining. We're just giving a couple of minutes, settle everyone in. We'll be starting shortly. I think we can start. It's 4:05. So good afternoon, everyone, and good morning to those of you joining us from Europe. Welcome to this fantastic webinar on legal strategies to expand your business in Southeast Asia, key steps to grow safely and successfully, organized by EuroCham Singapore and with the support and collaboration from Southeast Asia IT SME Helpdesk, the Spanish Chamber of Commerce in Singapore, and Craman. My name is Carolina, and I am Advocacy Manager at EuroCham Singapore, and I will be your host today. We have a great session ahead of you, and I'm excited to take you through these very crucial topics. Before we go, I would just like to remind everyone that no photography or recording of the speakers and presentations is allowed, but we are happy to share these at the end if you request it. So the session we have ahead, we will start by looking at a presentation from Álvaro de Luis, partner and head of the Asian desk at Craman. And we'll move on to the presentation from Max Ang, managing director, advocate, and solicitor at Gateway Law and Corporation. So thank you everyone for joining, and we will now start the session. Álvaro, the floor is yours.
Thank you, Carolina. And good morning, everyone. Good afternoon, everyone. Let me try to share my presentation. And yeah. So thank you very much for joining this EuroCham webinar. Today we will explore as swiftly and as easily as possible the legal strategies that European SMEs can use to expand their businesses in Southeast Asia. In general, our first objective will be to help you understand the different legal frameworks that you will encounter across the region. As you very well know, Southeast Asia is a diverse, very diverse region, both economically and legally. So selecting the right country and approach, legal approach, will be key. Second, we will examine the main market entry models available to foreign investors, such as subsidiary companies, representative offices, joint ventures, commercial agreements, and so on and so forth. Each option has, of course, different legal and operational implications in terms of control, liability, and regulatory burdens. So we will go through each one of them. Third, we will place a special focus on Singapore as a regional hub, given its legal stability and regional integration. And finally, my goal is to offer you practical legal insights for structuring your business in a way that reduces risk and supports tax efficiency in Asian markets. I will be using Singapore as a case study throughout the whole presentation, very specifically here with the legal structures that we will present. Very shortly, and by way of short introduction, let me tell you that Craman Lawyers is a Spanish law firm headquartered in Barcelona, in Spain. We do have offices in Madrid as well. We have a long-standing presence in Asia through our offices in mainland China. We are based in Guangzhou since 2009. We are in Hong Kong since 2012, where I have lived myself since 2012, actually. And Singapore, where we do have an office since 2019. We specialize in international business law, international tax law, international private law, And we do have a corporate services division as well, called NC Global. So we offer a full range of company setup and maintenance services, as well as legal services in both Hong Kong, Singapore, ASEAN, and mainland China. Let's focus geographically and politically what we are going to be talking about. As you well know, Southeast Asia is a very dynamic, very diverse region, composed of 10 countries that together form the ASEAN community, which was founded in 1967 during the Cold War. ASEAN began as a political initiative to ensure regional stability and cooperation, but it has since evolved into a major economic bloc. While it is not a political union, such as the European Union, it aims to function as a single market and production base, promoting free flow of goods and services, investment, capital. The most important thing, it represents over 680 million people, and it is one of the fastest growing economies in the world today. It remains fragmented in terms of regulatory frameworks, economic development, and institutional maturity, but it's definitely one of the key regions in the world in terms of economic growth and political significance. So we are going to be broaching the different legal frameworks that exist in the region, specifically in the ASEAN organization. And I would like to outline in this particular section 3 key legal dimensions that European SMEs should keep in mind when approaching Southeast Asian markets. First of all, the diversity of legal systems. Each country has its own legal tradition, which impacts how contracts are enforced, how companies are incorporated, and how disputes will be resolved. Second, we will cover the key legal areas that SMEs must deal with when entering these markets. And third, I will briefly touch on the limited but growing efforts towards legal harmonization within ASEAN. So first of all, as I have just mentioned, ASEAN is not a harmonized legal space. We will be facing a patchwork of national legal systems, each one of them with its own logic and with its own level of maturity. In terms of legal traditions, Singapore and Malaysia, for instance, follow common law, which is inherited, of course, from the British system. That means court decisions matter, contracts are king, and business disputes are often resolved via arbitration. But countries such as Vietnam or Thailand or Indonesia, civil law applies there. And civil law relies heavily on written codes and tends to be more formal and even state-driven. And then we have hybrid systems, such as in the Philippines, where Western legal traditions mix with customary or even religious principles. For SMEs, this legal diversity means that you will need to understand where are you stepping into. A contract that works in Singapore will require, for sure, many adjustments in Vietnam or Indonesia. So the same contract will not be equally valid in each one of these 10 member states. As I mentioned, while ASEAN has made some progress in harmonizing commercial rules, such as through mutual recognition and the ASEAN Economic Community, we are still very far from having uniform standards. And that is, as I will remind later, where Singapore plays a strategic role as a stable English-speaking jurisdiction that allows companies to base their legal structure in one place while expanding regionally. Another key aspect that we'll need to consider, every company will need to navigate through a number of legal areas that will directly impact how they operate, how they grow, how they stay compliant. And each member state will have different laws, of course, which are not harmonized, as I said. So first of all, we need to take a look at company laws, which include the process for incorporating legal entities, shareholder requirements, minimum capital, share capital obligations. This varies significantly across these 10 jurisdictions. Contract law, it goes the same with contract law. Although most ASEAN jurisdictions recognize commercial freedom, the enforceability of contracts and access to dispute resolution measures can vary. So again, Singapore offers very strong protections, while other countries will be definitely slower and more uncertain. Investment regulations. In some countries, foreign ownership is limited in specific sectors, as it is in China, or subject to approval by investment boards, such as you have in Thailand. You may need a local partner or a license to operate legally. You need to know what kind of license you need to obtain. Fourth, sector-specific compliance. If you are in areas like food, like tech, health, or education, be prepared to deal with additional licensing, product standards, or data protection rules. And lastly, labor and immigration law. Hiring staff, getting work permits, relocating expatriates will involve different levels of compliance that differ widely from country to country. So in short, you will need to approach the legal landscape in Southeast Asia holistically, not just from a tax or incorporation perspective, but with attention to day-to-day operational compliance. And as I mentioned before, like the European Union, ASEAN does not have a supranational legal framework. So each country retains full control over its laws, regulatory systems. There's some efforts, as I was reminding earlier, under the ASEAN Economic Community to reduce barriers and align standards in key areas like trade, customs, investment. And these efforts have led to some mutual recognition agreements and model laws, but implementation and enforcement vary significantly across member states in ASEAN. That's why, and I will repeat this a lot through presentations, Singapore often acts as a legal anchor in the region because its system is predictable, English speaking, arbitration friendly, and it is widely accepted as a neutral jurisdiction for regional contracts. In that sense, take into consideration that harmonization doesn't always mean uniformity. We will not have this in ASEAN in a long while, but harmonization, it can also mean strategically choosing a central jurisdiction that helps bridge differences. And that's where Singapore plays a leading role in the region. So let's take a quick look at the different market entry models that we will be facing in any region in the world, actually, specifically in Southeast Asia here, but this applies to any other region in the world. There's no one-size-fits-all answer. The right model depends on your sector and local regulations and your desired level of control, your risk appetite. But broadly speaking, we can group entry models into three categories. First of all, you can opt to establish a subsidiary, a wholly owned subsidiary or a representative office in your target country. Specifically, a subsidiary company will give you full control and legal stability, but of course it comes with some compliance and capital requirements and operational responsibilities. Second, you may opt for a joint venture, especially in countries or sectors where foreign participation is restricted. This has been a classic case in China over the years, although the scenario has significantly changed. Joint ventures often offer valuable local knowledge, but they require strong governance mechanisms and solid contractual protection. Third, many companies start with commercial agreements, distribution licensing agreements. These will allow you to test the market without incorporating any legal entity. But of course, it will depend entirely on your local partner for compliance and performance. So in the next slides, I will go slightly deeper into each one of these models, their advantages and their legal implications. First of all, I will focus on joint ventures, making a difference between equity joint ventures and contractual joint ventures. Equity joint ventures are typically structured as limited liability companies. It means that we will be creating a new legal entity with its own assets, rights, and obligations. A contractual joint venture, on the other hand, will be a contractual arrangement between two or more parties without creating a separate legal entity, which might be simpler to set up, but it's not always available or recognized in all jurisdictions. They are, for instance, clearly regulated and widely accepted in Singapore, in Malaysia, in Thailand. But in contrast, Vietnam, Indonesia, or even Myanmar present regulatory uncertainty, often require registration, licensing, and it's not that easy to use them there. Key differences between both of them: legal personality, liability, management structure. Equity joint ventures often offer legal clarity and limited liability, and contractual joint ventures provide flexibility, of course, at the cost of legal security. So, as a whole, joint ventures compared with subsidiaries, with representative offices, or with the absence of any legal entity of our own, present significant advantages. They will allow you to leverage your partner's market know-how, first of all. They will allow you to use your partner contacts, your partner's distribution networks within the country, which are often essential to operate effectively in Southeast Asia. You can benefit as well from existing client portfolios. You can operate under a well-established local brand name. In some countries, forming a joint venture may be the only way to gain market access due to some foreign ownership restrictions. Again, that has been the case in China over the years. But there's a number of disadvantages, or at least risks or limitations. If you choose a joint venture, you need to understand that you will be choosing limited flexibility to change the terms of the initial agreement once it is signed, because of course you will need to obtain approval of your partner. And misalignment with local partners is one of the most common sources of failure, leading to deadlocks or to falling short of strategic direction. You may face conflicts of interest, especially if your partner has competing businesses in the country. And let's not forget about IP risks. As Max will remind us later, and what I like to call here the enemy within. You must ensure your know-how, you must ensure that your intangible assets are properly identified and protected, even from your own partner within your joint venture with him or with them. Very quickly, representative offices, as an alternative to having either a subsidiary company or a joint venture, offer the simplest and lowest cost way for foreign companies to establish a basic presence in a new market. They are quick to set up, they usually require no registered capital, and they allow for initial activities like market research or building relationships with local stakeholders. They are ideal for early stage exploration of any market if you are not committed to a full subsidiary. However, they have significant limitations. They are not legal entities. They cannot sign contracts of any nature. They cannot invoice to any client. They cannot engage in any commercial activity. So their scope is very, very limited to non-revenue generating functions. And on top of that, liability stays with your parent company in your home country. And in some countries as well, you will need prior approval or even face restrictions on the number of staff you can hire or the number of activities you can engage into. Think of Malaysia as well. You will need to constantly renew your representative office, and at some point you will be asked to either close it down or transform it into a subsidiary company. So it's efficient from a cost perspective, but it is very limited from a practical standpoint to use a representative office. We normally do not recommend to incorporate rep offices, and we do recommend to jump directly into setting up a wholly foreign-owned subsidiary, which is the most robust and the most complete market entry model, because basically it gives you full control over operations and gives you the possibility to fully engage in any kind of commercial transaction by yourself. Of course, IP protection is also much stronger under this model because you do register your own trademarks or your own IP rights under this subsidiary in whichever country you are operating. You do not need to rely on your partner, in this case, for registration or for protection of your trademarks, for instance. On the downside, companies involve higher setup and maintenance costs. You might need to engage a company secretary. You will need to do bookkeeping to audit your accounts, and you will need to comply with local governance, tax, and labor regulations. In some countries, you will be facing sectoral restrictions as well, or you will need specific licenses. But in places like Singapore or Vietnam, for instance, this model is totally accessible. Overall, it is the preferred option when the goal is to have a stable, scalable, and compliant business growth in ASEAN. But in many cases, we recommend our clients not to engage into any incorporation and to proceed through commercial agreements with their local providers, with their local suppliers, with their local clients, at least for a while, until they are fully committed to having an actual presence in the target country. Think of distribution, agency, licensing, franchising agreements. They all will allow you to test the waters, generate revenue, build brand presence quickly and with relatively low cost and relatively low complexity, legal complexity, sorry. The main benefit here is speed, flexibility, and you can enter multiple jurisdictions through local partners. You can avoid the time and cost of incorporation, and you can maintain a light legal footprint from a regulatory standpoint. The hindrance or the inconvenient here is that this model carries certain operational risks. You will rely heavily on your counterpart for regulatory compliance. You will rely on your counterpart for reputation management. You will rely on your agent or your distributor for quality of your after-sales service. and disputes across jurisdictions are always a possibility as well. So the way you draft your contract definitely matters. And for sure, contracts that are valid in Spain or in France or in Germany or in Italy are not usable in any of these Asian countries. We need to adapt contracts. You will need to draft actually contracts ad hoc for each one of your transactions within any new region, actually in the world, but very specifically when you go into Asia. And well-drafted contracts should always include clear IP ownership and usage clauses. That's essential. Confidentiality protections, limits on sub-licensing, limits on sub-distribution, clear termination rights, clear definition of territorial exclusivity, and very robust dispute resolution clauses. Ideally, arbitration instead of ordinary courts. In some countries, it is better not to even approach ordinary courts. But ideally, as I say, arbitration in neutral forums, such as Singapore, will be probably some better option you will have to go for. So, to wrap it up, commercial contracts are a very powerful tool to scale regionally without setting up an entity in each market, but they must be tailored to local law and to business culture. A legally sound contract will be for sure your best insurance when you are placing your brand in someone else's hands. Let's take a quick look at Singapore, specifically at Singapore legal entities and Singapore's tax framework, because most likely you will be considering to go through Singapore at some point of your venture in Southeast Asia. So you need to know that, as any other country in the world, Singapore offers different legal structures for doing business, but in practice, private limited companies, which is a limited liability company in any other world, is the preferred option for foreign investors. Private limited companies combine flexibility, strong legal protection, and full access to the business ecosystem in the country. A key advantage of the private limited structure is that you will have access as well to certain tax incentives, which are not available for representative offices and for sure not to sole proprietorships. If you compare it to alternatives, as I mentioned before, representative offices are restricted to non-commercial activities, which is not a viable long-term structure, and sole proprietorships and partnerships are rarely suitable for foreign investors because they do have unlimited liability and operational limitations. So your best option will be to incorporate a private limited company, and you need to know that no minimum share capital will be required in Singapore to incorporate a company of this kind. You will need just one shareholder, either a legal entity or an individual, and just one resident director is needed. But this is a very specific requirement which distinguishes Singapore from territories such as Hong Kong, where resident directors are not needed. In Singapore, you do need at least one individual to act as a local director. You must also appoint a company secretary, who must be, of course, qualified, and you must maintain a registered office in Singapore, which could be your CPA's or your company secretary's office in Singapore. Thanks to the public administration digital platforms in the country, the Accounting and Corporate Regulatory Authority, namely, incorporation is quite fast and very efficient, which is one of the reasons why Singapore consistently ranks among the world's top countries for ease of doing business. I'm not sure if it's on the second or third place right now. Incorporating a company, a limited company, takes typically 3 to 5 working days, nothing more, provided that all documents are in order. The process will start with the preparation of corporate documents or ID verification in the case of individual shareholders, and legalization of all these documents when required, of course, when we are talking about foreigners. Once documents are ready, we proceed with typical steps: name reservation, we prepare all the incorporation and official forms, we appoint directors, we appoint company secretary, we submit the forms to the Accounting and Corporate Regulatory Authority, and within 5 working days, we can have the company incorporated. The whole process, the entire process, can be completed extremely swiftly if coordination with the client is good and we receive the documents on time. It's very important to notice that if you do want to open a bank account in Singapore, you will need to travel to Singapore and hold a meeting with a physical meeting with the bank. You will not be allowed, in most cases, to apply for a bank account open remotely or through video conference. But there are, of course, alternatives, and you can choose between traditional financial entities, just PPAs or this kind of banks, or CBC, or you can open bank accounts with fintechs, non-traditional financial entities. You need to know a few things about the tax framework in Singapore, which is extremely attractive, of course, and it is one of the main attractives of the territory. It applies a single-tier corporate tax system, which means that profits are taxed only once at company level, which means that dividends distributed to shareholders are not taxed again, which avoids double taxation of company earnings. There are also partial exemptions on startups that I will explain in a little while. You do have a sort of VAT in the country, which is called goods and services tax, whose current rate is fixed at 9%, which applies to most goods and services, including imported services and digital products, with some exemptions, such as financial services and residential property rentals. You must register for GST only if your turnover exceeds 1 million Singapore dollar, or if you want to voluntarily sign in, if you want to claim input tax credits. Otherwise, if your turnover is lower than 1 million Singapore dollar, you do not need to register for GST. As for salary tax, personal income tax is progressive, with rates ranging from 2% to 24%, which applies to income earned or derived in Singapore or from Singapore. There is no wealth tax, there's no capital gains tax, there's no inheritance tax. To qualify as a tax resident, you must be present in Singapore for 183 days or more in a calendar year. Or also, you might apply to two different administrative concessions that Singapore, the Inland Revenue Authority, utilizes. The first one of them, if you have spent 2 consecutive calendar years in Singapore and you spend a total of at least 183 days over those 2 years, the Inland Revenue Authority will consider you as a tax resident for both years, even if neither year alone you have met the 183 days rule. And you can also enjoy a 3-year concession, which means that if you stay in Singapore continuously across 3 calendar years, you will be treated as a tax resident in all 3 years, even if the 183 days rule is not met in any of them. What matters here is that you stay within those 3 years without significant interruption. And of course, Singapore is a zero-tariff economy for most goods, except for alcohol, tobacco, motor vehicles, and petroleum products. It's worth reminding that we do have a European Union-Singapore Free Trade Agreement in force since November 2019, which eliminated, I think, most tariffs on European Union origin goods and provides for simplified customs procedures, and it is a key pillar of European Union ASEAN economic integration. There are certain exemptions for startups, 3-year tax exemption scheme, which is quite attractive as well. And for companies aged 4 years or even more, there are partial exemptions, which are equally attractive for foreign companies. And let me tell you very briefly, before I exceed my 25 or 30 minutes time frame, a couple of examples of how can you structure your legal, or how can you structure your investment in the region through Singapore. These next 2 slides show typical structures that we do all the time, first from a tax treaty perspective, and then with a real life case that we have, where we have advised recently. When structuring regional investments through Singapore, one of the key advantages, of course, will be the extensive network of double taxation agreements with almost every European Union member state. And thanks to these treaties, dividend distribution from a Singapore company to a European Union parent company often benefit from reduced or zero withholding tax in Singapore. So on the European Union side, the dividends may also be exempt under your domestic participation exemption regime, provided that your local requirements are met. Such as in Spain, for instance, we do have our Article 21 of the Spanish corporate income tax. You must ensure at all times, if you want to enjoy the benefits of double taxation agreements, that you do have substance, economic substance in Singapore, which means demonstrating real economic activity, local staff, decision-making capacity, operational presence, tax advantages alone are not enough. Your structure must have a valid economic reason in the OECD standards. That's why Singapore is so attractive as a regional hub. You can operate there as you can use your company there as a procurement or sales platform for the region, providing the group with commercial visibility and having room to expand into joint ventures in the region. But this setup also makes very much fiscal sense. In other words, the commercial logic of using Singapore aligns with, if you align that commercial logic with substance, economic substance, and BEPS requirements from OECD, your structure will deliver strategic positioning and tax efficiency. So as an example, very specific example, this is a real case where we have advised a Spanish renewable energy company investing in Vietnam through a Singapore holding company. The client planned to develop several energy projects in Vietnam, so they set up multiple local subsidiaries, SPVs, as you can see there, in Vietnam, each one of them tied to a specific renewable energy plant. Under the Vietnamese law, every project required a local entity to hold the land lease, to hire staff, to obtain licenses, etc. The idea was to centralize the investment through Singapore, which would own 100% of the Vietnamese SPVs. So this structure offers advantages such as the taxation. Vietnam does not apply withholding tax on dividends paid to Singapore, and Singapore does not apply withholding tax on dividends going up to the European Union parent company. Under Singapore domestic exemption regime, dividends and capital gains, which are received from Vietnam, in this case, can be fully exempt as well. On the business side, the Singapore holding company added real value to the client because it acted as a regional procurement and sales hub. It helped attract financing and local partners, and it increased commercial visibility in the region. So this is just an example, very, very quickly summarized, of how smart legal design can align tax efficiency with commercial reality. It works out not only because of the tax incentives, but because of the structure making sense for the client's long-term expansion strategy into the region. So that's all. Thank you very much for your attention. It's been very quick, and I've tried to cover different aspects of a mercantile, commercial, and tax nature. I remain at your full disposal, of course, to answer later any questions or to explore any of the topics in more detail. Carolina, thank you very much.
Thank you very much, Álvaro. I am sure that everybody's now brewing over this information. We all knew Singapore was very attractive, but your presentation definitely provided that simple outlook on why it's an attractive hub. So thank you very much for the compelling presentation. I know that some of you might have questions, so please feel free to add them in the question box below. We will answer them at the end of the presentation. And now I will give way to the second segment of the session with Max Ng. Max.
Thank you very much. It was a very good presentation by Álvaro. I'll try my best to keep everyone engaged as well. Just a few minutes while I share my screen. Let me just get that going. If I can. Do you see it or not?
We see something else. We see your calendar.
Right. That's obviously not the right
Very,
one.
very busy calendar.
Just give me a minute.
No worries.
How do I?
At least we're blessed with a lovely background.
Thank you. Let me just get this up.
Perfect. We see it. Thank you, Max.
Okay. Is it good now?
Yes.
Right. Thank you. Okay. Well, let me just get to the first slide. Okay. So hello, everybody. My name is Max Ng. I'm Managing Director of Gateway Law and Gateway IP Services. We are based in Singapore and we have some offices in the region as well. Our focus lies in IP and technology law, and we regularly work with both local and international businesses navigating Southeast Asia's IP landscape. Before I begin my presentation, I'd like to draw your attention to the Southeast Asia IP SME Helpdesk, which is an initiative of the European Commission, and it provides free, confidential and business-focused advice to European SMEs and intermediaries. All right, so yes. On this slide, you'll see a range of the services that will be offered by the help desk. Firstly, through the inquiry helpline, you can send any IP questions related to Southeast Asia to the help desk, and you will receive a reply within 3 working days. Secondly, the help desk also organizes regular training workshops and live webinars, which are tailored to the needs of SMEs across Europe and Southeast Asia throughout the year. Please feel free to subscribe to the help desk newsletter via the website, and you'll be able to connect with the team on social media as well to keep yourself updated on its upcoming activities. The help desk website also gives you access to a wide range of publications in terms of country fact sheets, industry-specific IP guides, or general IP guides on various topics. These guides can easily be found on the help desk website. Last but not least, the help desk also offers learning tools such as an IP cost tool, which provides the European SMEs with a reliable overview of the costs that you may encounter with the registration of their IPs. If you're curious about the benefits of IP for your business, please do go ahead and schedule an online meeting with their IP business advisors of the Southeast Asia IP SME Help Desk via the link provided on this slide. You can also scan the QR code there. And as mentioned before, this consultation will be 100% free of charge for European SMEs. That brings me to my presentation proper for today. Now, I came across a statistic which states that SMEs make up about 99.8% of all European enterprises, and they generate over half of the EU's GDP, and they employ more than 83 million people. So very, very impressive statistics. However, in practice, I've also observed that IP is often poorly understood by many SMEs. So in light of this issue, I've decided to focus today on 3 key areas. Firstly, I will touch on the common IP challenges faced by European SMEs when expanding into Southeast Asia. Secondly, we will take a look at the IP frameworks that are available, focus on Singapore again, because as mentioned by Álvaro, it's a jurisdiction that you definitely will be encountering when you're coming into Southeast Asia. And finally, we will then take a step back to consider the broader ASEAN context as well, and how some of the international treaties and instruments may affect your IP strategy and protection going to ASEAN. In this next slide, we will see once again a map of Southeast Asia. And Southeast Asia, as mentioned by Álvaro, is as varied as it is colorful, as you can see from the map here, right? Every region is different. Each color differentiates, illustrates a different region in Southeast Asia. It is very diverse, but it's also very promising, and that also makes it a very challenging environment for IP protection. Overview of the various legal frameworks in Southeast Asia. As mentioned by Álvaro, we have civil law countries in Southeast Asia, and these primarily consist of Indonesia, Thailand, Vietnam, Laos, and Cambodia. We have the common law countries, Singapore, Malaysia, a small little country known as Brunei, but a very rich country, and also the Philippines, which is a bit of a hybrid as well. And of course, we have developing countries like Myanmar. What are the common IP challenges that you will face? We group these challenges into these different categories to better understand how businesses can protect their IP in Southeast Asia. It's important to consider the practical challenges that European SMEs will commonly face on the ground. The first challenge is oftentimes comes with identifying the intellectual property and the IP assets that require protection. Many SMEs tend to think only in terms of trademarks and patents, but this perspective overlooks a wide range of valuable intangible assets as well, which could be referred to product packaging, domain names, app interfaces, customer databases, promotional content, and even website layouts. Without a clear inventory of what qualifies as IP and as IP assets, businesses often risk leaving out essential parts of their business, and their competitive edge may often go unprotected. So what is required, and we remind businesses again and again, is to conduct internal audits, which can range from a simple internal audit to more complicated and complex ones. And to ask your business divisions, especially those that rely on branding and that those who create content or uses proprietary information, parts of your business which you intend to license, and these often, in the course of conducting these IP audits, will allow businesses to uncover significant assets that can be protected. The second issue that SMEs will face is a lack of local legal and IP awareness. One common mistake, therefore, often is assuming that the local IP rules will resemble those in the home country or in nearby markets. As we have continually stressed, ASEAN jurisdictions do vary quite widely, not just in the law, but in how those laws are often understood and enforced in practice. Even partners, distributors, or franchisees in different jurisdictions may have a different interpretation of how your contractual understanding may be enforced. Some of them may wrongly believe that they can use your IP freely simply by virtue of the fact that they have a business relationship with you. So without clearly and well-drafted agreements, there can be subsequent confusion about permitted and permissible use of your IP, or sometimes misuse, or sometimes even competing claims to your IP. Thirdly, and lastly, for now, there is oftentimes difficulty in enforcement of your IP rights in several of these jurisdictions. Singapore and Malaysia, as we have mentioned, are based on a common law system, have very well-defined rules and laws, operate on precedents, have very good courts. So they provide structured systems where they have trained IP courts, where the customs enforcement process is also well documented and in place. In other jurisdictions, however, like in Myanmar, Cambodia, perhaps parts of Indonesia, enforcement of IP rights still remains something that can be approved upon. So oftentimes these jurisdictions face limited administrative resources. They often face inconsistent judicial interpretation of the laws, or they just lack IP-specific training. In these countries, again, sometimes litigation may not be the most practical way forward in order for SMEs to obtain recourse. And SMEs should perhaps oftentimes consider what other solutions may be available besides just going to the courts in those countries. Coming back now to Singapore, and we're discussing, as a case study, the IP protection framework in Singapore. It is a robust legal regime. Its domestic framework has very well-established statutes, which are commonplace in other European countries as well, such as the Trademarks Act, the Patents Act, Copyright Act, Registered Designs Act. These IP legislation provide comprehensive protection across all major categories of IP. The system will also protect unregistered rights like passing off trade secrets, geographical indications, which are very important to European companies, and also often SMEs are also protected and now recognized in Singapore. And these laws are by and large, and rules and procedures are by and large administered by the Intellectual Property Office of Singapore, or IPOS for short. And IP cases are also heard in the courts by judges in Singapore who have specialist IP expertise. So what distinguishes Singapore, therefore, is, as mentioned, the predictability, efficiency, and the enforceability of its laws within the legal system that it has here. And these qualities, of course, are important to SMEs when they choose to expand into markets which may not be so familiar to them as their own home markets are. Legal proceedings in Singapore move quickly, can move very quickly, and there is also very strong confidence in the judicial independence and also in the procedural fairness in the systems that it employs in Singapore. Another strength of Singapore's IP ecosystem is its emphasis on alternative dispute resolution, also known as ADR, alternative dispute resolution. This refers to alternative processes of resolving disputes, and these can be in the form of perhaps arbitration or mediation. So rather than go through the traditional court litigation system, parties can choose to resolve their disputes through arbitration instead, for example, or through mediation, of which Singapore is a big proponent of. ADR can help parties save time, reduce costs, and also preserve the confidentiality of the matter of the dispute at hand, which can be a major concern sometimes, especially when dealing with sensitive IP assets. So Singapore offers multiple ADR pathways. For example, you have a very well-established Singapore International Arbitration Center, the SIAC, which is in charge of matters relating to arbitration. You also have the Singapore Mediation Center, or the SMC, and you also have WIPO, World IP Organization, which has also established an office in Singapore. So the WIPO Arbitration and Mediation Center has also been established in Singapore and now offers its services as well in resolving disputes through ADR. It has had a presence, WIPO has had a presence in Singapore since 2010. And, as most of you might know, it's neutral and it's also a not-for-profit provider and focuses on helping companies resolve their IP and technology disputes here. Singapore also provides subsidies to encourage parties to avail themselves of these services, of these ADR services. So all in all, these forums offer very business-friendly platforms to help most European SMEs resolve their IP disputes flexibly and also with other international parties. Further strengthening all of the above IP framework is the Singapore IP strategy, the latest one of which is the IP strategy 2030, or also known as SIPS 2030. Every 10 years or so, Singapore unveils its next 10-year map in terms of how to enforce and transform the IP sector in Singapore. So SIPS 2030 was a national roadmap which was designed to build a more innovative and IP-driven economy. And under this framework, SMEs could access funding, advisory services, capability building programs, all aimed at helping them to identify, protect, and commercialize their IP more effectively. Next, we will look at how some of the international treaties can affect and help you in the process. International treaties and agreements play a critical role in shaping IP strategy. These instruments provide legal certainty, reduce administrative burden, and offer cost-efficient tools for managing your IP across borders. A good example would be the EU-Singapore Free Trade Agreement, which was also referenced to earlier. It came into force in 2019. There is also the EU-Vietnam FTA, which was effective since 2020. Both agreements actually do contain detailed chapters on IP as well, intellectual property, and committed their various governments to uphold higher enforcement standards to improve transparency and to ensure that they provide effective legal remedies to the businesses. Treaties are not just about enforcement, of course. You also have filing systems. In the case of trademarks, we have the Madrid system. For patents, we have the Patent Cooperation Treaty, and there is a Hague Agreement for designs. And all of these treaties allow businesses to obtain protection in multiple jurisdictions through a single application process. So for SMEs with perhaps limited resources, these treaties definitely assist to streamline the registration process and reduces costs for the parties. So for example, using the Madrid system, a company can secure trademark protection in most of the ASEAN countries these days without actually having to engage a local trademark council in each market to protect your IP for you. Another key benefit, of course, is predictability. Given that enforcement can vary significantly from one country to another, the rules-based systems that are created by these treaties definitely reduce the risk of arbitrary decisions and provide access to international dispute resolution mechanisms. And ultimately, these treaties should also not be seen in isolation because they are part of a broader toolkit, and they work alongside domestic systems like Singapore's and regional initiatives like the ASEAN IP cooperation system. And for most European SMEs, leveraging all these instruments will help you to enhance your competitiveness, reduce your risk, and also ensure that your innovation is protected as you expand and grow into Southeast Asia. We'll look at some practical tips and recommendations next to help businesses navigate these IP challenges on the ground. Here we have some related guides that are published by the Southeast Asia Helpdesk. These guides help you with the various IP matters, and these guides will touch briefly on the Madrid system, for example, and they will also touch, other guides will touch on the PCT, the Hague system, and they will help you they'll give you a brief overview of how these systems work and help you to navigate through them. For example, the Madrid system, again, the guide in the Madrid system will teach businesses how to register their trademarks in multiple countries with a single filing through WIPO, which will then simplify and streamline the process for you, making it useful for SMEs seeking protection across the whole of Southeast Asia. Similarly, the same can be said for the PCT, which offers a unified procedure for filing of your patents internationally. Last but not least, of course, you have the Hague system once again, which offers protection for industrial designs across jurisdictions. So these three systems, which are the most common ones, will significantly reduce your administrative costs, burdens, and lower the overall cost for SMEs. So making IP work for your business strategy. IP planning, therefore, should be fully integrated with your business objectives. Whether your goals are launching a new product or entering into a licensing agreement or attracting investors, you need to identify, of course, which IP assets are commercially critical to your business, and then you should align your protection and IP protection efforts accordingly. For example, a software company may need to prioritize copyright and trade secrets, while a consumer goods SME, on the other hand, might wish to focus instead on trademark protection and protect your design rights as well. But the key is to identify early on which IP assets are core to your business model assess their potential value, and then determine how they should support your growth and protect them as such. One should focus on high value and high risk items and those that generate revenue for your company or which are crucial to your brand identity. SMEs should also do well to factor in ongoing costs like renewals, licensing management, and enforcement. Vulnerability assessments are also vital. A trademark might be available in the EU, but might already have been registered, protected in Vietnam. Or a patent which you have may not be enforceable locally in the country that you wish to enter into in Southeast Asia. So it's important to always conduct local searches and seek professional advice to prevent such missteps from happening. Lastly, we should also think proactively about monetization. Licensing your IP, whether it's your technology, your brand, or content, is, as mentioned by Álvaro, a low-risk way to enter into a new market with local partners. But this can only work if your IP is, in the first place, clearly owned, protected, and strategically reviewed right from the outset. So, as we come to the end of the presentation today, I just want to leave you with 3 key recommendations that we've touched on throughout the session. First, SMEs should always seek local IP advice. One of the most common mistakes that SME makes is assuming that the laws in Southeast Asia will resemble those of their home countries or neighboring jurisdictions. In reality, enforcement practices, the legal infrastructure, and even cultural attitudes towards IP can vary significantly across the region. Early consultation with local IP experts, therefore, can certainly help to avoid costly missteps and ensure that your protection strategies are both legally sound and market relevant. Secondly, do not delay your local IP registrations. While IP registration might seem bureaucratic or secondary sometimes, it is essential. In most jurisdictions, operates on a first-to-file basis. So delays can often result in someone else registering your brand name or design, whether on purpose or inadvertently. But once that happens, it makes it so much harder or even impossible for you to want to enforce your IP rights in these jurisdictions later on. So think also about protecting not just core trademarks or your patents, but also your supporting assets, perhaps your subsidiary product brands. And thirdly, one should always establish your key contracts in advance. Whether it's contracts with your co-founders, employees, distributors, or licensing partners, clearly drafted agreements that also address the issue of IP ownership and subsequent usage are very critical. Many disputes often arise because there are unclear assumptions about who owns what. So formalizing these terms very early on in the contracts especially as well will protect your interests and would give you a stronger foundation if enforcement becomes necessary later on. In short, a well-planned IP strategy is not just about protection, it is also about building a competitive advantage and creating long-term value for your business as you expand into Southeast Asia. Thank you. Thank you for this. Back to you, Carolina.
Thank you so much, Max. This session is a key element when it comes to creating a business and expanding into Singapore. And we're so lucky, well, in Southeast Asia, sorry, and we're so lucky to have had your expertise to guide us through this. So thank you so much, because this brings a very well-rounded conclusion to the presentation and the conversation we're having today. And also a quick shout out to SME Helpdesk that Max announced before. Do make sure to use the service, especially if you're considering coming into Southeast Asia. I'm sure we have many questions piling up. I can see them. So I'm going to open now the Q&A. Like I said, please feel free to also ask your question in the box below. But I would like to kick off this because I think it was a very interesting, we had two sides of the coin, right? And so I would like to start off with a very basic question that's always in everyone's mind, and it is, where do businesses go wrong? And this is a question for both Max and Álvaro, right? So where do they go wrong when trying to protect their company, their brand, their ideas in the region, right? And this is more for Álvaro, like what are the legal mistakes that European SMEs most frequently make when they're seeking to expand into ASEAN, right? How can they avoid them? I know this is a very big question, but it's the question that we already had a couple of people asking on our Q&A. So I just wanted to kind of round those questions up nicely. So maybe perhaps we could start with Max, as you, well, maybe Álvaro to kind of also, Max, you can drink some water because you've been, it's been a very long 30 minutes, but Álvaro, maybe perhaps we can start with you and then move on to Max. So common pitfalls and mistakes.
We see lots of legal mistakes actually in our daily practice, and we could range this common pitfalls and common mistakes in different through different angles and perspectives. But basically, first of all, and I have mentioned this as well as Max has, we can't understand that Asia as a whole is a single country. We can't understand that every country acts exactly the same way. We can't understand that ASEAN is a single market or a single jurisdiction. We cannot underestimate the regulatory complexity. Each country has its own legal, tax, investment framework, and incorrect assumptions about this complexity and diversity is one of the first major mistakes. Then, and I have said this in my presentation, we see how clients consistently choose the wrong market entry strategy. We have seen so many clients jump in directly into joint ventures with local partners with whom they have no previous experience whatsoever, with whom they have had no previous businesses, with whom they have not explored neither the market nor how they work together in a 20 years time span. We always recommend to start slowly, to start working with your local partners through commercial agreements, maybe to incorporate your own company if you think you do have business to make in the country. But joint ventures are like marriages, and you need to go through some dating prior to jumping into marriage, and that's one of the major pitfalls that we always recommend against. And thirdly, most of our clients, when they encounter problems with suppliers, with clients, with even with legal frameworks, they haven't done any previous legal due diligence. They have not tried to normally companies do not like to spend any money on lawyers. They don't like to spend any money on advice prior to starting their businesses. It is afterwards, when things have gone wrongly, that they seek for legal advice and they try to fix everything as quickly as possible. But it is at first when we are necessary, when we can conduct these legal due diligences and we can explain to them with whom are they doing businesses, what kind of legal requirements they will encounter in their ventures in this specific country or others, and how to stay compliant. If they perform this analysis ex ante, they will encounter lesser problems, or they will know how to face them. And they will for sure have a better way, easier way to deal with any kind of problem if they raise at all. So due diligence, hire a lawyer, and study your limits. As Max was saying, you do need to understand what's your list of IP rights as well. You cannot start working with any local company in any of these countries, in any country in the world actually, without having your red lists. What are you going to be sharing? What kind of technology transfer are you willing to make? And which is the main array of assets that you will be protecting, and at what cost? It's this kind of preparation is basic, and otherwise you will go through some troubled waters in any country in the world, actually. Max, I'm not sure if you want to add something to my premonitory answer.
No, thank you, Álvaro, for sharing the very comprehensive response. And I also tend to see many of the same issues that Álvaro has raised. I echo them. Definitely just as much as, you mentioned that many SMEs don't want to spend too much money on lawyers before actually entering into the business deal, conducting their due diligence and so on. From an IP perspective, I similarly see that, companies are also reluctant to spend on IP protection. And so they don't want to protect their IP until it's sometimes too late. And also, sometimes the worst thing that might happen as well is that as they are talking to prospective licensees in the various jurisdictions, the licensees will say, yeah, do you have IP? Don't worry, I'll take care of it for you. Or you don't, I'll take care of it for you. And then, they might take care of it, but they'll take care of it in a way that will not be very satisfactory to you. For example, they might just go and register your brand in their own home country already, but in the name of their own entities, right? Not in your name. And later on, they'll say, oh, I had to make sure that your trademark was protected before we talked any further. But then they protected it in their own name and not yours. So that's the kind of situation that you might run into if you don't take the proactive step of, spending a little bit more first, protecting your IP, conducting your due diligence before you jump into things. Yeah. And again, I think one way to understand just how different the various countries are in this part of the world is to, take some time off to come and visit Singapore and the surrounding countries. Don't just come to Southeast Asia to go to Bali alone. Bali and the beaches are not all reflective of the rest of the Southeast Asia, although they may be a very nice place to holiday too. It is very diverse, right? In some countries, the contract here is everything. And in some other jurisdictions, well, the contract is just a starting point. Yeah, it doesn't mean that, and they'd say, oh, let's change the terms as we go along, because circumstances change, so they have a very different attitude towards the written contract. Some jurisdictions just want to sign a one-page document. Some jurisdictions may say, we need to sign a very solid 30-page shareholders agreement, so it all depends on who you're talking to, which background they come from, and it's important. Yes.
Absolutely. It makes a lot of sense, especially as you both mentioned, cost is a huge concern for SMEs. So sometimes this kind of knowledge and guidance that they need beforehand, they might just think, oh, well, let's just shelve it here for when the problem comes, because what could possibly happen, right? And then it happens and they have to come running and the damage is done. And then it's harder to kind of backtrack. So absolutely, do your due diligence, do your IP protection beforehand. Absolutely. That's thank you so much for that insight. And on that note, you both talked a lot about local, and contract. And so in that sense, how can you find the right agency? What are the, because you both said they were powerful tools, right? The contractual contracts, if I'm not mistaken, that was commercial contracts, right? So if you don't have a presence yet, because Max, you're recommending people to come to Singapore, but perhaps, or Southeast Asia, sorry, I keep mentioning Singapore because that's where I'm based. But if you don't have that opportunity yet to come and you're doing it from far away, then how could you provide some good practices on when you're looking for these agencies and services, how to find them? What are the red flags that you should be looking out for when you're approached by a potential local partner or an agent?
Well, Max, please.
Well, I was just going to say that Google is a great way to start the internet. Of course, you have all these AI tools these days, but like ChatGPT and Grok, I see questions being asked of them all the time, but you have to take their replies or their answers with a pinch of salt. But certainly do scour the internet, do approach your local trusted legal advisors in your home jurisdiction, do approach the SME Helpdesk, approach EuroCham. All these organizations are there to offer you, a place for you to land upon and to obtain answers and to consult with before you make that next step. Yeah,
I agree. I do not recommend using ChatGPT that much, though. because I don't think it is reliable at all. And for sure, don't try to seek for legal advice on ChatGPT if you're not familiar with what you're looking for. But I agree with Max on the need for reputable intermediaries. And there's a whole array of European chambers of commerce across the region. I myself, I was sitting at the board of directors of the Spanish Chamber of Commerce for 5 years in Hong Kong, and I realized that many companies came to us when they already had encountered problems, and they never found, or they never came to us in order to ask for reliable law firms or for reliable consultants or agents or partners. People who are already on the terrain know people, and we have gone through our own experiences, and we do have the capacity to advise newcomers on how to avoid this common pitfalls and which doors to knock and with whom, which professionals they can work with. The European Chamber of Commerce, of course, and the national chambers of commerce are fantastic too. And there's also the trade promotion agencies. I think every European country, or most European country, has its own trade promotion agency, and for sure they will help you in identifying reliable professional service providers. As to the contracts, Carolina, you were mentioning this. I do have this question all the time. Can I use my French or my Italian or my German contract in Asia? The answer is no. Don't use the same contract. You do need to draft a specific contract for the specific transaction, and you need to adapt it to the specific details of your venture in whichever country in Asia you are entering. And to localize the contract is equally important. In many cases, we see how our clients feel more secure, they feel safer when their contracts are subject to their local European jurisdictions. And we need to understand that where we normally want to perform and to execute our agreements is in the destination country, in the target country, in the destination jurisdiction, where actually our partner has all the assets and all they have all their interests against which we can act in case there's a conflict and there's a breach of obligations as per that relevant contract. So this is a typical case with China, but it applies to any other country in the region. Actually, you might have a ruling favorable to your interests in Spain or in France, which you will struggle to enforce in other countries, in other jurisdictions. So always stick to the actual location of your investment and your operations. If you are working in Southeast Asia, you want to have your contract subject to Singapore law or to any to arbitration rules, which will be neutral and easily enforceable in Southeast Asian countries. And do not draft your contracts with ChatGPT. Please hire a lawyer to do that for you.
Yeah, we are survivors of the pre-ChatGPT era. Yeah, it's very easy and very tempting, right, to kind of cover and circumvent the costs when you have such a powerful tool. But don't let you wouldn't buy a house using ChatGPT, right? So
exactly.
Yes, exactly. We have a question for Max. Max, they're asking, what is the best country to start IP protection steps in Southeast Asia?
Okay. Best countries to start your IP protection steps. I mean, certainly you can apply for just one or two countries, whether you choose Singapore or not. I mean, certainly you should target the ones that you're going to enter into directly first. But you know, when you're applying for extending your IP rights to Southeast Asia through something like, for example, the Madrid system, actually the cost increment to just add on an additional country is not that much in larger scheme of things. So you can easily consider applying for 4 or 5 of the 10 Southeast Asian countries straight away, you know, because the cost differential is not so much. Speak to your local trusted IP advisors or approach the SME Helpdesk. I think they'll be more than happy to guide you along and allow you to do a cost comparison when you're undertaking this process.
Okay, thank you, Max.
Yeah.
For Álvaro, I think both, they haven't specified, but for a person thinking of starting their company in Asia, what is a checklist that they should follow?
What is the what? Sorry,
A
you repeat that?
checklist. So steps. What are the
checklist.
steps? Yes, things that they should consider, prioritize.
Everything that we have already said. In order to start a business or in order to incorporate a company, can you please
Start a
clarify that?
business. Start the business.
Start the business. First of all, again, conduct a thorough due diligence. Check the records of your potential supplier, of your potential distributor. It's quite simple for a lawyer to check the legal and litigation history of any company in most countries. Check their reputation, backgrounds, corporate records. See whether the person who's speaking on behalf of your potential distributor or supplier is actually the legal representative of this company. Whether the company exists. I've seen cases where foreign companies were dealing with companies for a while, thinking that that company actually existed, and it was not an existing company. It was just a group of people doing business on behalf of a phantom entity. Use reputable intermediaries. Do not start any businesses without having done, as I said, before drafting a proper contract through a reliable law firm, or even ask for advice from your local chamber of commerce. Insist on transparent agreements and actual agreements. Do not start working with anybody without having clear rules in writing. We see many cases where businesses start operating without drafting any kind of contract with their suppliers or with their clients, on the basis of trust, on the basis of urgency, on the basis of 1G or whatever, however you want to name it. It's very important to have a set of instructions, just a set of rules that you will apply throughout the commercial relationship between the parties. It does not affect the trust. It does not affect the friendship that you may even develop with your counterpart. But if you do not have a contract at first, which is clear, which is transparent, which compresses the full array of rights and obligations that both parties will be assuming, when there is a conflict, you will not know how to react. You will not have any actual legal resource to claim for compensation for breach of any obligation which has not been previously formally expressly described on a piece of paper. So draft your agreements in writing, and establish compliance standards as well, and make sure that your expectations are to be met in terms of IP, for instance. You might want to have your brand protected. You do not want your brand to be distributed in certain third tier cities or supermarkets or brick and mortar stores. And you do want to have compliance standards defined and regularly checked. So do not go to Southeast Asia, have a couple of dinners with your potential partner, start a business with them, and go back to your country without having defined the rules on a contract, establishing local presence and establishing regular compliance checks. And really, my personal advice to any European SME is to have somebody on the ground. Do not go there, start your business, run away 12,000 kilometers westwards and think that everybody will respect the original deal and will work for your benefit. You need to go there. You need to be there if possible. And if you cannot be there, find somebody to be there for you. But you cannot be successful in Asia or in Europe, vice versa, if you don't have anybody there. We do have different business cultures. There's 7 hours time difference. We do things very differently. You gotta be there. It's impossible to succeed otherwise. Sorry for the long answer.
No, I think it's a very comprehensive answer. I think they were expecting a couple of points, and this is a very comprehensive list. If anything, it just reinforces what both of you have been saying, which is the importance of doing your homework before, of actually making sure that you have all your ducks aligned, right? So absolutely, thank you so much for that. And it kind of ties nicely to the second question that we have for Max. They're asking, because you're talking about brand protection, right, Álvaro, here. So is it easy to enforce your IP rights in Southeast Asia? Do you have any practical tips to share to be prepared?
Sure. I think it's fairly straightforward enforcing your IP rights in Singapore, because it's a very well-defined jurisdiction with very clear rules, clear legal systems. So then it will be a question of how do you want your IP rights to be enforced if it comes to that? Do you want to go through the court system, or do you want to go through something a bit different, like using arbitration to resolve it, for example? There are several benefits to the arbitration process, confidentiality being one of them, and we can have a whole separate discussion on arbitration versus the court process, but I think today is not the time for it. But definitely it is very possible to enforce your IP rights in Singapore. That said, Singapore is geographically and physically speaking, it's the smallest country in Southeast Asia. So if you're going to be doing business here, you're unlikely to just want to look to the Singapore market. You're not just going to sell to the Singapore market. You're probably going to be looking at some of the larger countries like Vietnam or Indonesia or Philippines. So you need to consider how you're going to structure your business such that it has a very typical structure that Álvaro highlighted earlier on. In the case study is that you have Singapore company as your holding company, and where the wholly owned subsidiaries may then be in the other jurisdictions, whether it's in Vietnam or some other jurisdiction. That is actually a very typical structure to have Singapore as the holding company, in which case then you have to consider how would the enforcement of IP take place vis-a-vis Singapore, vis-a-vis the other countries as well, and how the contractual relationships would be set out between the subsidiaries, the parents, the joint venture partners, and so forth. And if there's a dispute between any of these various entities, how would those disputes be resolved? Whether it's IP disputes or some other type of disputes, how would they be resolved? Should it take so by way of arbitration? If arbitration, should it be in Singapore or some other jurisdiction? If it's by mediation, again, where will the mediation be conducted in? Again, whether it's conducted in Singapore or in Vietnam. I've had the experience where the mediation started the arbitration process actually started in Vietnam, but then it got moved over to Singapore halfway through. Sometimes that's possible as well if both parties agree to it. So there's a lot of moving parts to this issue, and all I can say is don't rely on ChatGPT to give you an answer to this question alone.
Because in that sense, Max, how effective are the IP rights enforcement mechanisms? Because you mentioned a couple before, right? So how effective are they? And yeah,
they're very effective in the sense that, for example, if you think your product is a patent protecting your product in Singapore and it's been infringed, you can very easily take out a patent infringement lawsuit in the Singapore courts, and Singapore courts will deal with it quite efficiently and quick and fast. Yeah, so it can be very efficiently dealt with.
Thank you. If anybody has a question, we're gonna wrap up soon. We have 10 minutes left. There's one question that's for Álvaro, and I know this is a Spanish person because they're asking if you could provide some clearance between the autónomo figure and the sole proprietorship.
In which jurisdiction?
In which, sorry?
In which jurisdiction? I mean, sole proprietorship exists in different jurisdictions, and it's treated differently in Singapore or in Thailand or in Malaysia. But basically, yeah, it's the most similar legal figure you can encounter in these countries, the sole proprietorships with the Spanish autónomo. You do have to consider that if you are a sole proprietor in Singapore, for instance, you are a non-incorporated entity, and the business and the owner of the business are the same legal entity. You will not have any separation, any differentiation between your own assets, your personal assets, and the business's assets, which is quite important because your liability in this case will be unlimited, and it will be personal. In general, both in Singapore and Hong Kong, I do not recommend to incorporate any sole proprietorships because of this unlimited liability, considering that incorporating private limited companies is extremely easy and relatively cost efficient. You do not want to face personal liability when you can have limited liability through a Hong Kong limited company or through a Singapore private limited company. It's pretty much the same thing, really, to this regard. I mean, you do need to file your personal taxes. In the case of Spain, of course, you do need to file your impuestos sobre la renta de las personas físicas. In the case of Singapore, you will need to file salary tax as well, with a range of rates that I mentioned earlier in my presentation, from 2% to 24%. And in the case of Spain, you do need to contribute to your Social Security or to your alternative Social Security system, which in Spain we call RETA, which is the special regime for trabajadores autónomos. In the case of Singapore, though, you will not be forced to contribute, or you will not be obliged to contribute to the Social Security system, which is called Central Provident Fund, unless you are a permanent resident, unless you are a citizen of Singapore or a personal resident, permanent resident, sorry. If you just happen to be in Singapore with an employment permit, and you've been there for 6 years, but you just have an employment permit, you do not have become a permanent resident, you are not obliged to contribute to the Central Provident Fund. Whereas in Spain, you are always obliged to contribute to your Social Security or to your alternative regime for trabajadores autónomos. Apart from this, it is pretty much the same thing. Again, you do need to register your business, you do need to obtain your business license, so to speak, and you need to file your personal taxes on a yearly basis with a very specific caveat of your personal liability taking place at all times. So really, Singapore or Hong Kong, shouldn't be your first option, except in very, very, very specific cases that should be very carefully considered. In most cases, you want to have your limited liability company. And if you leave Singapore, you just deregister it, which is quite simple to do. If you don't have any debts, if you don't have any liabilities, you will be able to deregister the company before you leave and take back your money with you, if you have made some money.
Thank you, Álvaro. Max, is there anything here that you would like to add?
No, I wholly agree with what Álvaro said. You know, it's a really almost like a no-brainer to set up a company in Singapore. It's really easy and fast, and something you should definitely do. Unlike certain other countries where you may, in addition to setting up the company, you may be required to put in a minimum amount of capital, whether it's 100,000 or whatever the amount is. In Singapore, there's no such requirement at all to put any capital into the company here. So it's very easy to do.
Thank you. If we don't have any more questions, then we've reached the end of the session. Want to thank everybody who joined us today. If anybody has any follow-up questions or have any questions that have remained unanswered, please email them to us at EuroCham, and we will make sure that it goes to the right person. It's the same as if you're interested in the presentations from today, please email us. I would like to thank once again Álvaro and Max for their time and their knowledge. It's great hearing from you and tapping into your expertise. It's such a privilege to be able to hear these things firsthand. And like you said at the beginning as well, Max, thank you to Southeast Asia, IPSME Helpdesk, and the Spanish Chamber of Commerce as well. Thank you so much. We look forward to seeing everyone else at our other events. Thank you so much, everybody. Have a great afternoon.
Thank you very much, Carolina.